Hi everyone, this is DeRolo Nixon from Nixon Disability Law, coming to you again as part of our Veterans Month campaign, where we're bringing you 30 videos with history, trivia, and important information for and about veterans, and about the communities they serve, and also with information for them to help them and to help the people who support them understand how to build a strong VA disability benefits claim. In today's portion, we're talking about the relationship between VA benefits and Social Security disability insurance benefits. And today we're going to focus on how the different statute that the Social Security disability insurance benefits scheme comes under provides for a different standard for how to be found disabled. You guys ready? All right, let's go. So for Social Security, under the 20th title in the Code of Federal Regulations, okay, talks about how one is found disabled. And so notoriously, Social Security has a 5-step process. VA does not have a 5-step process. Social Security has a 5-step process. Here are the 5 steps. First step is SGA. It stands for Substantial Gainful Activity. In a certain way, it's similar to substantial gainful employment on the individual unemployability side, but only on the surface is it similar, okay? On the Social Security side, which is what we're talking about today, SGA, or Substantial Gainful Activity, is a fixed dollar amount. And so you either are at it or over it, or you're below it. That's it. There's no other options, okay? And there's a special one that's different when people are alleging disability under the Social Security Act because they're blind, okay? One of the reasons Social Security disability insurance benefits was created, okay? The program, I mean, not the benefits themselves, but one of the reasons it was created was for blindness, to help blind people be able to get some support, because in the 1930s, during the Great Depression, it must have been awful trying to look for work being blind and having to compete against people with full sight. So that's part of how the Roosevelt administration, got this passed by Congress to do this. And so there's a separate SGA amount for blindness. Anyway, that's only one of the differences, okay? But that's step 1, SGA. Step 2, the step where the judge will determine, or the Social Security person performing the 5-step analysis will determine if you have any severe medically determinable impairments. In the weird world of Social Security, because that's what it is, a weird world, okay, a severe impairment does not mean severity or severe the way we think of things, okay? If it's affecting your functioning on a daily basis, even if you take medicines, that's severe. If you only have it once a month, but when you have it, it puts you in bed for a whole day, that's also severe, even though it's only occurring once a month, okay? Step 3 is the most complicated step. It's the listing of impairments. Social Security has effectively divided the body into 12 or 15 different parts or systems, and they've put specific diseases with specific symptoms and other factors into the listings. And if you meet or equal one of those listings, you win at step 3. If you don't, you actually move on to step 4. At step 4, the judge has to determine, or the Social Security worker, and of course, I do tons of these hearings. I've done, 15 to 1,700 of these hearings in 12 years. So almost 12 and a half years. Anyway, so that's the frame I bring to this, okay? So step 4, what the judge has to determine is, could you return to your past work? At step 4, the judge will determine what your residual functional capacity is. That's your maximum remaining ability to do certain tasks and to tolerate certain events or experiences, okay? And then after forming the RFC, the judge has to determine, again, that's my perspective, the judge has to determine, could someone with this RFC return to your past work? If the answer is yes, you lose. If the answer is no, but the grids don't apply, you then go to step 5. Step 5 is the first time that the government has the burden to prove anything. Again, this is distinguishable from the VA system, where at least there is a duty to assist, right? And so on appeals in the VA system at the board level and above the board level at the Court of Appeals for Veterans Claims, one of the primary assertions that is made, certainly in all of the appeals I do, right? But I suspect in other attorneys' appeals, is to claim an error in the duty to assist, okay? There's no such thing on the Social Security side, okay? At steps 1, 2, 3, and 4, they are not, the agency is not under a duty, okay, to do very much at all. Okay, you have to prove your case. When we get to step 5, however, the government has the duty finally to do something. The government has the burden of proof at step 5 to show that there are jobs in significant numbers in the national economy that someone with your RFC could do. If the answer is yes, you lose. If the answer is no, you win. And so that's a little bit about the two different standards, okay, from the two different statutes and regulation systems that distinguish VA disability benefits from Social Security disability insurance benefits. And so next time we're going to talk about evidence. I'm going to talk about a problem that my veteran clients have in bringing their Social Security claims. Thanks.